All right. Shall we begin the session now, ma'am?
Sure.
All right. So, good evening, dear participants. We are happy to have you guys here for our sixth webinar in our Child Rights and Wellbeing webinar series organized by Law Comrade by myself, Subramaniam, and Ms. Kritika. So, I'd like to introduce to you guys our beloved speaker. So it is our honor to introduce our distinguished speaker for today's webinar on advocacy for child offenders and their rehabilitation as part of our webinar series. So Advocate Sneha Singh is a dedicated child rights lawyer based in Delhi with an impressive 9-year career in litigation. An alumna of Campus Law Center, Delhi University, she has a formidable background in handling high profile cases. She has previously worked as an associate counsel in significant anti terror cases, including representing accused persons in the Mumbai blast and Delhi blast cases. Her experience also includes assisting in the representation of renowned figures such as Stan Swamy, Gautam Navlaka, and Vinayak Sen. So currently, she operates as an independent criminal lawyer and serves as a panelist lawyer for HAQ, Center for Child Rights. In this role, she has been entrusted with over 50 cases under the Protection of Children from Sexual Offences Act, providing vital legal representation and support to child victims, both at trial courts as well as appellate forums. Her dedication extends to representing juveniles at the Juvenile Justice Board and Children's Court, ensuring that young offenders receive the advocacy that they need. Moreover, in 2022, she was a valued member of the inquiry committee constituted by the Delhi Commission for Protection of Child Rights to assess the legal aid provided to children in conflict with law at the JJBs. Your expertise and experience and unwavering commitment to child rights and justice makes you an invaluable asset to our webinar series, ma'am. So we are honored to have you here. The forum is yours. Thank you.
Thank you. Such an elaborate introduction. I am overwhelmed by this. Hello, good evening, everyone. So today's topic was advocacy and rehabilitation. I should share my screen now, right?
Yes. Yeah.
Okay, perfect. See, before, Subramaniam, I'll take this few minutes to introduce
Yeah.
something. See, I have been following the lectures and I saw that there are history of juvenile justice which has an evolution, right, and which have not been covered. And without
Yeah.
that, this whole series would be a bit,
Incomplete.
incomplete, right?
Yes.
So I'll just take this opportunity and liberty without you assigning me this.
Yes.
Yes. So I'll just share the next. Right. So when we talk about JJ is not what we see as of now or it's of 2000 or something, right? Pre-colonial, I have also followed the lecture. Pre-colonial era, we were mostly governed by our respective religious act, religious regulations and principles and laws, respective. Coming to during colonial era, which is starting from Regulating Act 1773 to 1950. I've divided it like this. So the during colonial era from 1773 to 1950, there were major drastic changes and elaborations developments which need certain elaboration on the specific reports and laws of the India. Right. First being, sorry, where did it go? Yeah. First being the Prison Disciplinary Committee, 1836. After the T.B. Macaulay report, which commented on the prisons in India in general. After that, there was a committee constituted for prison disciplinary committee, called as disciplinary committee, which highlighted that children are the vulnerable persons who are also being incarcerated in jail with the adults. That was the first time which is being, in a passing reference, this was highlighted, a concern was made, right? Meanwhile, prison disciplinary committee came up, then there was other acts during which certain, every time there was a view on this, but nothing concrete came out, right? The first time when it came out was an apprentices act 1850. What is it about? It said that certain children within age of 10 to 18, especially focused on orphan and neglected children, but also had a provision that if a petty offense has been committed and if it is being tried by a magistrate has the power to refer this child as a apprentices, and to assign to certain person who can give a qualification or a certain skill, which, and the purpose was that skill should be such that after attaining 21 years, that child should be employed and be capable of having a livelihood. So it was not some random skill, it was a very specific identified skills for which would make child capable of earning a livelihood on attaining 21 years age. And the contract or the agreement which happens between these two were the parents or the caretaker of the child, and between the person, I mean the employer or the apprentice person who has been assigned this apprentice, right? After that, 1850 continued further, but 1815 only covered with respect to petty offenses charges, right? And in 1860, IPC was introduced, right? IPC section 82 and 83. 82 talked about dolly incapax, which said beyond 7 you can't commit a crime. So mens rea cannot be assumed when it comes to child below 7 years, right? And the 83 said that 7 to 12 you'll have 7 to 14 you'll have to have certain maturity, which needs to be proved and assessed by the courts to determine or impose a criminal behavior to you or the conduct to you, right? Meanwhile, this is coming up and everybody was concerned seeing the conditions. Also in this colonial era, there was a lack of skilled laborers, and especially the youth can contribute because they were not having much political alignment to join or not join, right? A whipping act came 1864, right? What was this? Under whipping act, there were certain offenses for which if a child has been found, if a child or a person has been found to be found to be convicted of an offense, he would be rather sent into prisons, would be whipped for certain. It was a different category for adults and for a different categories for children, right? And the intention was to uh, divert more and more children from the criminal justice system at that point of time. Although this was not much based on the juvenile justice of today, what is the thinking and orientation we have, the whipping act was not this. It was made, it was just to divert certain population so as to have more and more skilled workers at their disposal. Thereafter came Indian Jail Committee 1864, right? Indian Jail Committee 1864 also highlighted certain things and just made a passing reference with respect to jail children in jails and their incarceration with the offenders. Meanwhile, Reformatory Act 1876, this was particularly for the youthful offenders. Youthful offenders from 16 um, and up to the age of 21, who had been committed certain acts, and instead of sending them to prisons, they were made to go to a reformatory schools act, which have been uh, managed by the local government or state governments that time to provide certain skills. That the same was again amended in 1897 when local government was given the powers with certain more privilege to the children, that if a cruelty has been found by the licensee is the one who is the person who will be taking care of uh, that particular child, right? Then came CRPC 1898, which authorized magistrate to send offenders to reformatories instead of prisons, probations, and release on probation and juvenile court instead of the normal criminal justice system. The sections were respective sections are there. Thereafter, also there was an act which was Criminal Tribes Amendments Act 1897, which was very specific to children of tribes, right? Certain nomadic tribes. Basically, it was for nomadic tribes and reformatory schools with respective to that nomadic tribes' needs, because their needs with respect to other tribe, normal people were different. I mean, the other caste children were different. Then the most important one was Indian Jail Committee in 1889. Indian Jail Committee 1889 for the first time highlighted that there is a need for, because up till now they were acknowledging the fact that yes, children are every now and then being found in the jail with the adults, but they have not been came up with an idea that okay, fine, this is keep on happening, now what should we do, right? Then 10 something point 10 was with respect to 8089 committee, which said that there has to be a segregation, right? There is a dire need to segregate the juvenile offenders or the children's and the adult offenders in a prison or a jail system. The most contrasting one was the Indian Jail Committee of 1919 and 2020, which said no prisons for children, and said and also suggested of aftercare, and there were a lot of other suggestions, but the notably ones are these. Children, okay, after that what happened 1919, after 1920 there were different acts and statutes with respect to uh, various states, like Bombay Boston School Act, right? Bombay Bostels Act, Tamil Nadu Act, Bostel Act. There were different acts under which also the children were being sent to Bostels for getting reformed and with the requisite skills. There was also a Vagrancy Act 1943, which was which also identified the neglected children, but also it also helped intervened at the point, the breakout points. The neglected children are the ones who were actually going towards the delinquency and later on being the offender. So Vagrancy Act tried to attack at the very roots of the problem, and also identified certain categories like the children who have found begging on the streets, then who were in unfit guardianships, then the children whose parents are drunkard or criminal habits. So there are also certain other conditions like if the house is being every now and then visited by a prostitute or something like that. So any immoral conduct which is being happening, any immoral or illegal conduct which is being happening in the house, or if a member, particularly parent or child, is associated, a parent or I mean father or mother or any other household person like relative, close relative is represented, then so Vagrancy Act provide for certain provisions in which child could be sent to homes or orphan homes, or the SOS families were at that time. SOS families could be developed to uh, later on support these persons. Right? Now, after after 1960, right, 1950, we had our constitution. Then came independent India. Now this is post-colonial India. The first act, Children Act, was if we talk about not the unified, it was the Madras Act. Madras Children Act was a 1920 act, but it was a state specific. right? The first central legislation came into 1960. And to point to be noted is the Madras 1920 Act is the model act at that time. So even the Children Act 1960 were also having a lot of provisions and the schemes of the 1920 Madras Act 1920. 1960 was the first which said that which put prohibition of imprisonment in any circumstances of children. So the children can now be not incarcerated under certain age. But what is the problem with this at the point prior to 1960 and post 1960, right? Prior to 1960, there was no act with respect to right. 1960 Children Act came, but it was this children were the state subject, and hence every state were having their own legislation with respect to it, and the age in each legislation were different, right? And this can, if we'll later on go, we'll find this, that in 1983, 1880, 1880, there was a report of All India Mullah Committee which said that there was 2000 around children all over India who were incarcerated at that time, found by the Mullah Committee, right? And because of this thing, because that time every state were having different laws, and every state there was a different age, there were different provisions with respect to how. And in one stage it could be 14 years, in another state it could be 16 years. So that was the first time. Children Act 1960 also introduced the discriminatory age. What is it? Like for 16 for boys and 18 for females, right? Thereafter, the same act was amended in Children Act 1978. Okay, so now here my advocacy point came. Before 1978, lawyers were not allowed to represent the child, right? The concept was that those laws state are functioning as parents patria, thereby meaning that the state would protect the child as a father protect its a child, and there hence there won't be any need specifically, because a good faith has been imposed on the state, and hence lawyers were not allowed at that point of time prior to 1960. 1978 amendment allowed the lawyers to intervene now and represent child legally. Then it came after a case law, which we'll cover in the coming slides. Then coming to 1986, 19 since we have been following 1960 to 1978, we have been having that separate legislations in every state, and this problem of treating children differently in different states keep on coming and coming, right? And then Sheila Base is the person who first advocated in 1983 and filed a habeas corpus in Supreme Court for release of 1,400 children incarcerated at different states of India at that point of time, right? And subsequent to that habeas corpus, India was forced to form the first Juvenile Justice Act in 1986, which was a uniform law, meaning thereby that now there would be one act, one definition of child applicable to all over India in each state, right? Thereafter, JJ Act 2000, as we know, but you will look at this, the Juvenile Justice Act 1986. The intention of, can you see this stark difference? The 2000 Act have this care and protection, right? In Juvenile Justice Act, this term care and protection were also added in 2000. Why? That we'll see later on. Then it which stands currently as repealed. I think Justice has already spoken about 2000 Act, but uh, just to that it has to be in conformity with the international, because you India has signed UNCRC in 1992, and hence it has to comply with, therefore, this act, right? And also the definition of children below 18 years were also implemented, right? Then now we are having 2015 Act, which introduced legal fiction via preliminary assessment. That's section 15, saying that a child is not a child as per the definition, but still be tried as an adult, which is, we still are pondering about how it is possible, but that's a legal fiction. Then came to support, there were certain gaps which were unfulfilled, and there, so to complement 2000 Act, there was a 2007 rules, model rules, and for 2015 there are juvenile care and protection model rules of 2016, which are amended in 2022 recently, right? And now, as of where we are standing, is with Juvenile Justice Act 2015, along with 2016 model rules and the recent amendment of 2021. So this is the evolution completely. You have seen how we have came across, right? From the concern of where a child is being going into the legal system with adult, and then the everybody, the society panicked and tried to come up with various interventions with respect of whipping act, apprentices act, reformatory act, and other kind of vagrancy act, criminal tribes act, reformatory borstal acts again. But after 2015, we are again demanding the child to be kind of treated as an adult, and we are pushing the child into the criminal system. Right. Now, coming to advocacy. Going back to where we started, that when lawyers were not uh, allowed to represent a child and how it happened, right? This is the case Cardio Mansingh Mallu and others versus State of Gujarat. It was a Gujarat High Court judgment. For the first time, this contention, three child offenders were were charged for theft offenses, and they were tried by they were produced before the juvenile court that time. That's what we call the children court that time, or juvenile court, right? And then what happened, they have been granted bail, but they were not allowed to represent, because the charge sheet final report was filed, and on final report the children said that we want to be represented by councils. However, the president of the juvenile children court that time, it used to be, they denied and passed an order saying that this is a law which is parents patria, and which is based on the concept of parents patria, and hence there is no provision of being represented by a lawyer. So the court, it was sent to High Court for in reference. Later on, when the reference was being decided, it was, the arguments were made in light of Article 22 of the Constitution, and also it was held that yes, Article 22 is being violated by such section 22 of the okay, the concerned legislation for this was Swaraj Children Act 1954, because we are talking about post 1960, where the every state were having their own children acts, right? So Saurashtra Children Act of section 22 of Saurashtra Children Act were found violative of Article 22 of the Constitution, and it was said that fine, you are going with the concept of parents patria, but when you are detaining a person, when you are curtailing liberty of somebody, they have a right to be represented, to answer. Another contention which was taken by the offenders or the children's were that since police was filing a report, PP was also were arguing their case. So if there is already a lawyer for the state's argument, why can't we be having a lawyer? And that's how the first time when lawyers were allowed were this, because of this case, which was this is a 1968, and then it was followed by 1978 amendment of JJ, sorry, of Children Act, which said which allowed lawyers entry in the courtroom. Right? Now, coming to advocacy, there are certain principle of child rights litigation, which is not, I'm not talking about section 3 of the Juvenile Justice Act. Those are the principles on which juvenile justice system is based. These are child rights litigation principles, or you can say, right? The first could be approach of law. See how we have seen the brief evolution. How we have came towards is the first time when the state has started with the children's laws, it was moving towards from a very parents patria concept like protectionist approach. Then it came to welfare approach. Welfare says that okay, state will provide you with certain services, but it will be confined to what I have, right? You cannot ask something more than that. Whatever welfare schemes are there would be provided to you. Thereafter, as of now, where we are standing is a child rights approach, right? Where a child can say, okay, this is my right and I want this. This has to, if you don't have the place for making, you have to make place for amenities, for situations, for moving stakeholders apart, and channelizing every resource of the country to make space for my right, if there is a right conferred on me or identified for me. Okay, so the principle of first thing was the right based approach is the first, which we need to constantly remind ourselves, because JJ has a lot of stakeholders, and when there are a lot of stakeholders, the agency of the child or the participation of child somehow diminishes at each stage. That we have seen. Then making a case for juvenile justice. What is that? Right? What is that? Let us explain from section 12 example, right? Section 12 says bail to a juvenile, right? It says bail to a juvenile. And do you have section 12? Anybody? Can someone read out? No audible.
Section 12 is bail to a person who is apparently a child alleged to be in conflict with law.
Yes, ma'am. The child shall be released, right, ma'am? Can you read it out the entire section? I'm really sorry to.
No, no problem. When any person who is apparently a child and is alleged to have committed a bailable or non-bailable offense is apprehended or detained by the police or appears or brought before the board, such a person shall, notwithstanding anything contained in the Code of Criminal Procedures of 1973 or its any other law for the time being in force, be released on bail with or without surety, or placed under the supervision of a probation officer or under the care of any fit person.
Thank you so much, ma'am. So, yes, now this is a simple plain reading which you get that okay, fine, in bail, if any child is being apprehended and produced, is brought before the court, he shall be granted bail. It looks so simple, right? But there is this recent study of I pro bono where you saw there's 9,000 plus children who have been incarcerated in adult prisons, right?
Yeah.
That is adult prisons. Okay, fine, let's forget about that. Also, in particularly now, there we have been going to JJB's, ma'am is also there, and there are a lot of people, we know that as a fact bail is not being granted on the very first day, in especially in serious cases and a lot of heinous cases. Although you have seen that section 12 completely bars any kind of focus on the nature of offense for bail, right? The only
Recently,
condition,
the Pune case.
right now, yes. So the only conditions are three exceptions. It looks very simple. Now, anticipatory bail, is that in the concept? No. But Still now, how many? There have been different high courts interpreting it in different ways. Some says there is a provision, there isn't a provision, and they all talk about 438 whether it can be granted or not. But Section 12 is a very comprehensive law which says that whenever somebody appears or not appears, can I?
You're on mute.
Can I take 5 minutes? Just
All
yes.
right. Participants, you are requested to kindly be patient. The speaker will be back in about 5 minutes. Thank you. Vaidehi, ma'am?
Yeah.
Oh, yeah, she's back.
So, what we're talking about, that it looks very simple, but how are we making way for section where did that slide go? Yeah, making a case for juvenile justice. So there are three exceptions. Now, if we see that three exceptions are very broad, let's focus on that, because as a matter of fact, the language is very clear that for a matter that whenever a child is produced, he shall be released. So that is the condition. But that three exceptions are being used very vaguely and deliberately to deny the bail to a child, right? What are those exceptions? One is the exposure of exposure to some criminal association or something. Then there is moral corruption or physical harm and all. And third is with respect to the imam. What was it? In defeat the interest of justice. Right.
Yeah.
Right. Now, if you try to understand this, if I go outside my house, who would be the persons who won't be there, right? Should a child living in a particular area will change the entire house or surrounding for that? So, as a matter of fact, how bails are being denied to a child, right? In that, there are specific case laws wherein the court have to step up and define that the defeat of justice, right, have to be seen in the context of children's perspective, right? The defeat of justice is what justice? It's juvenile justice and not the traditional concept of victim versus offender, right? It's not that kind of the case law. If you can go for this elaborate, is CCLA versus NCT of Delhi. It's a criminal bail application of wait yeah, it's this one, CCLA versus as State NCT of Delhi, bail application 2510/2020, Delhi High Court. Although this is Delhi High Court, but it has a very elaborate discussion and it's a very elaborate judgment. And then it has also talked about all of these three exceptions and how they have to be rationalized and justified in the order. Like the for Devrat versus there was a case law, Devrat, which was with respect to defeat of justice. Now that which says that defeat of justice has to be seen in the context of juvenile. So is he being denied is his incarceration is being seen as denial of his rehabilitative opportunities or any kind of emotional well-being? It has to be seen in that sense, right? Second, Nand, it also discusses Nand Kishore, which says the judgment of Delhi High Court only, I guess. Nand Kishore says about known criminals, that the court which the exception which is talking about exposure to certain known criminals, they have to be identified. You cannot mention in your order that random person, that you can't just leave it that okay, if the juvenile will be granted bail, he'll be exposed or will be a company of certain known offenders or would be morally corrupted. Those the identified criminals has to be specified in the order, or some reference has to be connected with. Then there was a defeat of justice, known criminal, and What else was there? Yeah, same. The Cecil A versus NCT of Delhi, which was Justice Bhambani's judgment, had clarified that how we should put a case of a juvenile in such cases where we see the provisions advocating for it, but in practicality, it's not happening. So, Section 12 instance is very specific is how to make a case of juvenile justice in the system during child rights litigation. Now, amalgamation of law and realities of societies. What is this about? Yesterday, I was attending the lecture of the family one, in which there was she talked about collective will versus individual will, and why a law, or for instance, this Pune case which Vadahi ma'am said, why we have an outrage with respect to this, because the law is very, if we are going through law, section 12 says it has to be released on bail, irrespective of X, irrespective of everything. But why society is not conforming with the same thing? Why? Whenever we push for child rights litigation, it's not just law. It has to be society's value also, and everyone else, right? So we have this comprehensive stakeholders, right? The probation officers, different, and especially provision in JJ which says that if the board finds CCL also to be a CNCP, he can be referred to CWC for rehabilitation and proper orders. Right? So these kind of stages which shows that there has to be, you cannot, lawyers or the law in itself cannot deliver juvenile justice to a child. It has to be a collaborative effort. Social workers has to be consulted, their view, their parents view, the society how it's perceiving. That's how you grow up on child rights, right? Otherwise the same Pune case will keep on repeating, wherein the bail has been granted and then has been revoked. And I don't know, in law how can you do so, especially in juvenile justice. Then upholding the principles of juvenile justice. Now, upholding the principles of juvenile justice is relating to Section 3. Section 3 of juvenile justice, which says a lot of certain principles, the most contrasting being the participation, best interest, and all of that. But one very specific section which I need to highlight is Section 3. Section 3 of juvenile justice, and it's the seventh Roman 7 positive measures, right? What are positive measures? It says all resources are to be mobilized, including those of family and community, for promoting the well-being, facilitating development of identity, and providing an inclusive and enabling environment to reduce vulnerabilities of children and the need for intervention under this act, right? Does it talk anywhere about the criminal propensity or anything about that? No, right? It just says that if a child has been identified in a system, and and the system has come up with certain vulnerabilities of that child, all kind of positive measures have to be taken. Suppose a child has been brought, apprehended, and brought before a board. The board finds that um, it's a petty offense, or if it finds that the child has not committed the offense or might have been an accident or something, they can refer it to CNCP, because as a CNCP to CWC, or they can also pass their own order. But what I'm trying to say here is that a child doesn't has always to be with a criminal propensity before the board or the juvenile justice system to be addressed any kind of vulnerabilities which has been identified, because that's the intention of this act, to rehabilitate and reintegrate every kind of children. That's why it's taking into consideration neglected children as well as the delinquent children. Neglected, as once later on it was, the word was used, neglected children, in the earlier legislations. Later on it was given the name of child in need of care and protection, right? So because there is this theory which always prevails and has been also justified, that the neglected children are the potential children who goes toward the delinquency and came up as an offender. right? So not to wait for that and start working at the roots. So this positive measure one general principle which is there in section 3, it's particularly important because it tells about that not only certain criminality has to be seen, but all kind of measures. Thereafter, concepts of parents patria. Okay, now this is very interesting because this first approach, right, the first principle which says that protectionist to welfare to right based. Now we are on right page where children says that okay, don't slap me, teacher cannot slap a child, and then there are contentions that okay, how should we discipline a child because there are rights, right? And then and the Pune Posh case or any other case in which which you assert a right, because there is a Hoffman's theory, right, where there is a right, there is a corresponding duty, liability, or duty. But in case of children, that is not true. Why? Because they have been given certain rights, but they don't have the responsibility as of now because of our legislation, because of the evolution of their mind, their brain, because of their dependency, vulnerability on the society as a whole. That this concept of parents patria cannot be done away with, because what I have been seeing nowadays is family. Yes, family is the first unit and the interaction point of a child. But if you see nowadays how many hours a child spend outside the family, right? How much you just try to see, um, 7 hours or 6 hours of schooling. Then there were a lot, because my niece is 2 years old, she goes to play school and all of that, contending to 5 to 6 years. So it's not just family, she goes outside and she grabs everything from the society, whatever she gets. So it's also the society, and if a society is not like that, which is also the responsibility of the states, then you cannot give away, you cannot get away with the responsibility of parents patria from drawing from the concept of parents patria in uh, in the name of the right of the child. Okay, it's a lot of it's is it getting boring?
No, ma'am.
No, no, no.
Okay, so because I'll just give an example. How if any one of you have been in love marriage? Because if a person does a love marriage, then how the family responds is okay, you have done it, now it's your right, you have not gone for an arranged marriage, now we cannot solve your problems, it's your discretion, you as you have exercised it, now liability is on you. That's the same concept which we can see nowadays, because anyway, because all of these debates, whenever such cases of like any kind of juvenile cases which have some kind of brutality comes up, this attitude of society that okay, you have been asking about rights, now you have exercised your rights, now also carry the responsibility of it. But that couldn't be the case in everything, because children are what they are because of the society. It also a reflection of society, children are a reflection of society, right? For another instance, if a child of 2 year, a toddler falls on the roof while playing, the first thing it does, it's like, hit the surface to find that kind of, or he starts crying, so you will go and console, okay fine, this has been done, okay, let's do. That's a kind of deterrence we all evolve with. That is the animal perspective which we all have been born with. I have this theory that ultimately we are born as an animal, be it social animal or anyone, but we are social. And then with the society we develop, we are modified to behave in a certain conduct, to come up with norms to how to behave, how to talk, how to react in certain situations, to curb that animalistic tendency with us. So what I'm trying to make a point here is that the parents patria of the state cannot be given up on the fact that okay, now the child has right, and the family is the first unit which it's coming into interaction, so the family and the child has to take up everything. Now suppose for this Pune case, there was a breach of the license, the child, okay fine, he was getting, but there was nobody checked, the liquor was provided to the, there would have been the instances where he has been violating certain traffic norms, have been told, because our society has been like, you bribe somebody, you get away with it. I'm not saying in this case it happened, but these are the instances which keep on happening. And as a society, we keep on looking away or ignoring these facts. And until and unless it aggravates, it leads to delinquency, it leads to become a child offender, and then we react with instant aggression and selective outrage. Okay. Now, coming back to my second, how much time do I have, Subramaniam? Is it a time bound session?
No, it isn't. No, you can
Okay.
take your time. Yeah.
Okay. Now coming to rehabilitation of child offenders, right? Let's also start with some kind of example. What can you see in this picture, right? There are flowers and all of that. I made a very flowery presentation. Wait for the new sunrise, right? Now you have a plant. It's not growing on well. It's not according, it's creeping in some other direction, or some it's the leaves are wilted or something. You'll change the soil, right? You'll maybe try to put it in the sunlight, you'll water it less, or maybe just change the soil and everything. And then it might show result to you, might not show result to you, depending upon the specific needs of that plant. Same with the children, same with we as a human being, as a unit of the society, right? Whenever a child offends or the delinquency, we blame children instead of looking at are the circumstances or the situations are the same in which we are expecting him to grow in a certain way, in a certain perception of the society. Is that the all the facilities, resources, kind of environment which we are seeking to be a ideal environment is being provided to the child or not? If not, you have to take place the child from that environment or that particular conditions into certain circumstances which you think or as a society has nominated that these are the valid conditions, or these should be the suitable conditions for this kind of behavior which we are expecting from a citizen, from a responsible citizen. So are these children, because whenever we talk about rehabilitation, a lot of debate goes around that these children have this tendency of repeating, right? So are after coming into the juvenile justice system, have their condition been changed? Have the entire sets of skills and resources channelized on them? Did it change the entire perspective of the child in a way to give him chance to change or rehabilitate and go in the same society and not to act? It's a very demanding change we are asking from a child, right? Now I will not lecture about this. I will rather, let's read out some provisions, right, which makes it very clear that what should be and what is the intention of the act, starting from preamble. So I'll start with it. Preamble starts section, right, Juvenile Justice Act 2050, an act to consolidate and amend the law relating to children alleged and found to be in conflict with law and children in need of care and protection by catering to their basic needs through proper care, protection, development, treatment, social reintegration, by adopting a child friendly approach in the adjudication and disposal of the matters in the best interest of children, and for their rehabilitation through process provided and institutions and bodies established hereinafter, and for matters connected therewith or incidental thereto. Right. So the preamble is very clear. We expect that there is Juvenile Justice Act, and the juvenile offenders would be treated or punished or be But that is not the intention of the act. The act, the very first line, the preamble says that no, I'm not dealing with the criminality, nothing. I just have to see that children who are identified in the system and have been brought as a delinquent child or as a neglected child or has been identified as children in need of care and protection, they have to be rehabilitated and reintegrated into the society, right? They are very clear. So what stage rehabilitation begins, that's a very important question, because what happens now, that's the preamble, that's how we are starting. The law is how we are starting. That reintegration and rehabilitation was the concept. Now coming to section 29, what is definition of best interest? Definition of best interest is a very commonly used principle, and everything denying, allowing, granting to a child is the concept. So it reads as section 2 subsection 9 talks about best interest. It talks about any decision, right? Mind this thing, that any decision, be it bail, be it a normal routine decision of allowing a child to this place or not, whether the victim should be placed in a vulnerable witness box or not, whether this child should be made to heard the victim testimony alleging him to be a very barbaric person or not, every step has to be backed by this principle. Any decision has to be backed by the best interest. Now best interest, what I have seen in the orders of JJB or children's court, or for that matter others also, it's just written best interest, but even that best interest has to be rationalized on the basis of different things. What is best interest? Fulfillment of basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. So that best interest which you write and get away with in orders, it's not so simple, right? To deny a bail, to say that interest of justice, the best interest of justice to to keep the juvenile in the protective custody. No, you can't just write best interest. You have to rationalize and give explanation, because on these points, that the identity, basic rights, and all kind of these things will be better served when he is being in protective custody or any decision which you are making. Now section 2 subclause clause 40 read with section 47. What does it talks about? Observation homes, right? Section 240 is observation homes. Now in this, if you read out the definition, I'm not going to read out, it's because of time, paucity of time, but it's for observation homes are for temporary reception, care, and rehabilitation during pendency of inquiry under this act, right? That's it's the language of the act. I'm not interpreting it, it's written there, that observation home during pendency. So when the rehabilitation begins, from the very first instance, right? Because you keep observation home after production. Also if you're not granting bail, you'll send the child to observation home, and at that time also, from the very first day also, it starts. So identifying the children's need and working along with that line, that is the first motive and principle of juvenile justice, which is carried out from the very first day when the child is introduced as the system. Now section 240 read with section 47 is observation homes, elaboration on what are how it should be, who should like section 240 only defines observation home. 47 is a dedicated provision for 47 observation home. And then section 246 is for, sorry, section 246 is for place of safety, right? Now observation home is for CACLs. What does that mean? Child alleged to be in conflict with law, those are during pendency of inquiry are kept into those homes, meaning thereby that the child has not yet been found to be committing of an offense, commission has not been done, he has not been found. Place of safety is where CACL or CICL has been kept. CICL are the ones when the child has been found to be of committing of certain offense. Those also with CACL, more than 18 years and above. Receive and take care. So place of safety's definition is also like same. Receive and take care of children by order of JJB or children court, both during inquiry and ongoing rehabilitation, right? So even because place of safety is usually associated with heinous crimes or with kind of serious offenses, that okay fine, these kind of children would be going into place of safety. Even in that time, the intention of the juvenile justice is very clear, to go with rehabilitation even at that point of time and for those children as well. Now, section 256, read with 48. What is it? Section 2 subclause 56 is a special home. This is also for children who have been found to be in conflict with law. I mean, the inquiry has been completed and they have been found to committed certain offense. It is for their housing and rehabilitative services sent by order of board. Now, have you seen how we are moving towards the act? When we started, it talks about rehabilitation. It talks about every decision has to be based on a concept which talks about also about the child's specific conditions and development and needs, and not about any kind of offense related or criminality related stuff, right? Then we came on the places where the child are being placed during the inquiry or after the inquiry and throughout the system. It's very clear that we have to work for the rehabilitation of the child and not with respect to not to wait for certain rehabilitation of the inquiry to happen or to be completed. Now, later on, the section 3, 7 or 8, it was positive measures, which we have already read. That positive measures means that whenever a child comes into the system, we channelize every resource whatever is needed for rehabilitation of this child. Section 8 subclause 3 and clause E, what is it? Can somebody read out please for me, so that it should be engaging one? Can you get section this one to read out? Section 8 subclause 3 E. What is it about? It's about social investigation report. Yeah. So it talks about a report which has to be filed when the child is apprehended, produced before the board. Within that production, within 15 days of that first production, the probation officer or the child welfare police officer or any social worker. So have you seen how these things are made, that even there are 3 options given so that it couldn't be violated? If the CWP is not there, then a social worker could be appointed for making this investigation report, social investigation report. Why I'm telling you to read it out is, it's if you open form 6 model rules of JJ Act model rules 2016, right? Let me check in my computer.
I'll share the model rule. Will I share it?
Yeah, please.
So you want Form 6 to be read or what?
No, I want it to be displayed.
Displayed.
Yeah.
Yeah.
Yes. Thank you so much.
Yeah.
I just wanted to show that how elaborate it is, and how
also
elaborate.
nature of offense alleged also it is there.
Right. Social investigation report for children in conflict with law. Right. From, can you see how elaborate it is for the ones, of course, the ones who are in the system knows about it, but there are others also who have joined. Can you see sex, religion, mother's name, whether the child is differently abled, then all of those things. Can you scroll it down? I cannot do it. Yeah.
Yeah.
Family details, can you see? Right. So when we are talking about that rehabilitation, name and relationship, age, sex, education, occupation, this is, and mind it, it has to become within 15 days. Now, within 15 days, your final report is also not submitted. But this is required. Why? Because the sole purpose is rehabilitation, as to also keep a track of certain things. How the board is going to treat this child, history of mental illness, addictions, if any. Such an elaborate report is being asked by the board, right? If the person is married, name, age, spouse, and everything. It's important to show this because so that people know that it's JJ is not letting child offenders very just letting them skipping off the criminal responsibility. What we are doing is we are trying to identify the vulnerabilities of a child and to rehabilitate and reintegrate from the very first day of the child. And how we are going to do is these kind of things. So whenever we say that the child has been identified with certain propensities or the allegations of criminal behavior, it has to be traced down that what are the roots which contributed in it. Is it family? Is it society? Is it the environment within which he is living, or anything? And then if that could be identified, how we should place that child. So in with respect of this report, even the bail can be denied, that if you've seen that these things are not cannot be corrected at this point of time. There is the CCL case which we have been discussed, the Delhi High Court judgment that has called for SIR. That is also discussed that the SIR has been not called up while granting the bail. Right. So okay, I'm done with this. Just scroll it down once so everybody can have a glimpse that how elaborate it is. This is prepared by CWPO or probation officer or social worker, whoever is available in every district. Yeah. See this habits of the child: smoking, alcohol, drug, gambling, begging, any other, watching TV, movies, everything. Nothing is going out of children's opinion. Now, see this one 22 point children's opinion, reaction towards discipline in the home, right? Employment details, details of income utilization and manner of income utilization, work records, details of education of the child.
Sneha ji,
G.
see in SIR when format, there is one column called nature of offense alleged, petty, serious, heinous. Do you think when we say principle of innocence or assumption of innocence, this column is okay or not okay?
Nature of offense.
Yeah, alleged offense.
No, it's just saying alleged offense nature. So, which can you point out the exact?
When a form 16, form 6, no, initial itself it comes FIR number under section so and so police station, nature of offense alleged. So I always feel this column is contradictory to the
Principle of
principle of
innocence.
assumption of innocence.
Right. I don't think so in the sense that, see, I find counseling report more violative of that that principle. This for me is okay that suppose sex crimes. Sex crimes are crimes of passion. right? That's how it has been identified in criminology. So that is the nature of crime. Instead of that, how police is using it is entirely different. That he has gone, he has done this, and that is not the nature of crime, which how they are kind of filling it up or coming up with. So that's my stand, that I don't find nature of crime here, where it is that it is committed by child, no, alleged to be committed. So I'll give that liberty to it. But counseling report, I find it very invasive of the privacy, because also board also used while dealing with section 15.
I agree.
That, yes.
Continue the screen sharing. Sneha, your video and audio.
Yeah, can you go back to the slides? Can you stop how to stop this?
Yeah. I'll stop sharing. You can share the slide.
Right. Yeah, so we were talking about this one, right? Section 8, Form 6, right? So the whole intention was to show this. Now, if we can relate this to Rule 10, Rule 10 of Model Rule 2016 talks about what? Summary inquiry, right? It's nowhere written there that it's a summary inquiry expressly in Rule 10, subclause 1, right? Rule 10, subclause 1 says post-production processes by the board. Sorry, is my video off? Okay.
Yes, ma'am.
Yeah. So it says, on production of the child before the board, the report containing the social background of the child. This is not SIR, that's SBR, which is filed by police on the very first apprehension, along with the FIR. They also file a report, which is called social background report of the child. So along with that report, circumstances of apprehending the child and other alleged and other offences alleged to have been committed by the child, as provided by the officers, individuals, agencies producing the child, shall be reviewed by the board, and the board may pass such orders in relation to the child as it deems fit, including orders under section 17 and 80 of Act. Right now, 17 and 18 are what? 17 and 18 are what? When you either found the child to be committed of an offense or not have committed an offense, right? That kind of orders. Now, see the scope and intention of the Act. On the first production, you have been produced, and then the first hearing, which is, we are saying it here as summary inquiry. In the next section, when you'll read, no, section 2, rule 10, clause 2, if you'll read, it is referred as summary inquiry. In all case of release pending inquiry, the board shall notify the next date of hearing not more than 15 days of the first summary inquiry. So this is the first clause. Whatever inquiry we are saying, it is termed as first summary inquiry. And on the first summary inquiry, the board has so much of power to either pass a section 17 or 18 orders with respect to the offenders, which will bring to the effect to the case that the child has been found or not to be found as an offense. That could be taken on the very first. And the only documents which are required are SBR, basically FIR, social background report, and the other explanation which the police or the authorities give with respect to how this child has been apprehended or not. Now, this particular rule 10 has not been complied with in most of the boards in Delhi also. Because I personally go and we see, when we make a point, it's always said that the offense is serious and we cannot grant it so at such a stage until the final report or the final report by the police is submitted. But does this act talks about it? No, right? So the intention, what I'm trying to say, that how the rehabilitation is moving towards, like you start with the act with such intention, then you have a concept, then there are homes, then your first production also, if there are documents which says that it's a case being made out, you can go get away with certain provision, and with the help of law you can push the child to, instead of pushing him to a criminal justice system or to a more technical judicial system, you can also get the child into the rehabilitative process right from the very start using that provision, okay? Section 8 subclause 3g is the one which we are talking, is transfer. It talks about when a child is produced before the board and board sees that this is a child which is more of a neglected child, and hence is identified as one of this category of child being in section 214 of the JJ Act, which are termed as CNCP, child in care of need and protection. Board can transfer the child to the board, and together they can work together. That's what the act says, that the board has identified the need that both the bodies has to work on the child, right? That's the language of the act. Then section 8 subclause 3 and h, it talks about individual care plan. Individual care plan comes when there are two plans, right? We talk about social investigation report, which was basically telling about what are the problems, what has been the problem of the family background, everything. Now individual care plan is a very dedicated plan devoted to a child's specific needs, right? And this plan has to be made up with the participation of child also. If you read out later on, it will be also the section, the forms, the form 7 is given in the moral rules, which also has like child is also made a participant in that while evolving certain what should be, because it can't be a box fit same box approach, no, every child cannot be kept in the same box, right? Hello. Huh? Yes. So the ICP is also very elaborate, and that's how the rehabilitation starts from the very first production, goes till the last. So any order which is being seen as a disposal order. Now there is a controversy in this, that in cases of petty offenses, when we say that inquiries, if it's not completed in 6 months, it can be terminated. Proceedings will be terminated. So should we have final disposal in that final disposal order? And the final disposal order, should it have the individual care plan? What are your views? Let's listen. Anyone?
Every disposal order should have ICP.
Right,
As well.
ma'am. Yes, but
Practically it doesn't happen.
yes. So what do you think? I mean, that does termination, how boards are seeing it, as that the termination has happened because of the legal technicalities and the impediments, but why they are not identified that the child might have been delinquent? There have been certain delinquency which could have been identified. So why cannot that be addressed while disposing of the matter? Right. Then moving forward is section 2, subclause 56, read with section 48. It talks about special home for CICLs. I think I have read this. Yeah. This is also about the same, that even when the child has been convicted and an individual care plan have been proposed for him, it has to be followed as well, right? So rule 82A, which is in the previous to be read with section 83, rule section 83 talks about individual care plan. Form 7 is the specific needs and what is to be done. 82A is also the follow up, which is given that what was being followed was there was an individual care plan, but there was no follow up on that. So how we would ensure that the child who has been identified with certain vulnerabilities have been throughout the system, now those vulnerabilities are being worked upon, or either they are being effective or not. So in 2016 model rules, rule 82A was specifically introduced for this effect, for the follow up on the rehabilitation plan. And if there is some need, then also we can 79 and 82A, sorry. So there is also one rule which allows that while child is being from institution, was released from institution, he is being given with certain amenities, right? That is very interesting as well, which talks about how holistically and comprehensively the JJ system is looking towards the rehabilitation of the child. Now, having said that, let's see certain violations. Let's talk about certain how we have this. This is about the incarceration, right?
Excuse me.
Mula committee, yeah, please.
Actually, in my experience, Sneha ji,
Ji.
once a child is found guilty, we send the child to the special home for 1 year or 2 year, whatever it is.
Ji.
Then there is afterwards there is no meeting of the child before the board at all. Then it is discretion of the superintendent of the home and things like that only. Whereas in child welfare committee, when the child is there in the institution, we keep getting quarterly progress report and ICP, and every now and then we are reviewing it and we are giving the suggestions. It is being considering all the points, evolving capacity, everything. We keep amending the ICPs also. And
Right.
once a child is about to be restored, we also make pre-release plan and post-release plan also. Whereas
Right.
same thing should come in the children who are found guilty or sent to the special home should be done. But it is not happening practically.
A, can you read out, ma'am? Rule 82A. The board of the children court, the restoration and follow up for children in conflict with law.
Yeah. In rules, is it? Or section 1?
Yeah, it's rule 82A.
Restriction follow up with conflict with law. Form 44 before the release of child place in child care institution.
Yes.
The order of restoration shall include ICP and all is okay. So what I am trying to tell you is when the child is
Yeah, you are saying that no follow up is being reported to JJB.
yes, because the child is there. Say suppose the child is found guilty, then we make the order for 1 year or 2 years, whatever the place of I don't call it punishment, whatever the time the child has to spend in the special home. Then there is no monitoring done by the JJB. In my 3 years of experience, I have not done it.
Okay. So
once we get the child in the special home,
that
ends the matter.
rehabilitation card, do we doesn't it get
No, it
people?
is not. No, that rehabilitation card is I think 54 or something. But it's
Yeah,
not for
rehabilitation card has to be because child may not be produced before the board, but that
actually the report should come. The report should come.
Rehabilitation card has to be continuously produced before the board.
Used or during our visit, we may see the child. That is also a different issue. But as such, there is not much robust mechanism of viewing the things, because even we don't have any power to review our own order also. So that is the thing, no?
Okay.
Vijay ma'am, you're very right, because even I have observed in my experience in JJB, when once we release the child, we presume that whatever charges or whatever offense he has done, or after confession or after punishment, the child is overnight, matlab, the vulnerabilities has reduced. Because we forget that we are restoring the child back into those circumstances. Maybe uh, he has undergone his punishment time, but once we are sending the child back in the open environment, the child may further be exposed to the uh, conditions under which he committed crime earlier.
Yeah, that's what you are talking about after release. I am talking about during the time also. Not much monitoring happened by the JGB. That's what my point is.
I too agree, ma'am. I am speaking from Jammu and Kashmir. We don't even have a special home or a place of safety. We only lodge our children only in observation home till now, even after 10 years of 2015 Act in place. So the condition on ground, the act, no doubt, is very benevolent, but the condition on grounds, I hope you also agree with me. On ground, what conditions do we have? The staff, the probation officers we're talking about, they are also under litigations. They are outsourced. They are employed from outsources. There's so much tussle in between DCPUs, CWCs, JJBs. Matlab, the act is some, the ma'am has rightly in written ki this is a new sun. I don't know when it is going to rise.
Right.
Thank you.
Ma'am, Shalini ma'am, can you throw some light on section 20 also? Like when the board has found the child to be a CCL and have prescribed certain term of stay, and the child attains 21 years of old, and the periodic evaluation has to be done with respect to the progress of the child. Is that being complied with, or even that is not being complied
No,
with?
ma'am, nothing is. And JNK, ma'am, I would love to share the cases of four children who have been accidentally migrated from Pakistan border. They have completed their sentences long back. And those children are still lodged in observation homes. We have nothing for children, these countryless children. JJ Act does not talk about these children, about their rights. And we have no NGOs working on ground. But the system in J&K is abhi itself is juvenile.
Right.
I don't understand ki after completion of a sentence,
Hmm.
how can a child still be
That would be
lost?
illegal detention actually.
Yes, ma'am. And but who is accountable? Please tell me. When we are talking about rehabilitation, whom to make? Until and unless we have forcible, I don't know, I'm not getting that word. जब तक हमारे पास एक अच्छा follow up mechanism नहीं होगा, या जब तक हमारे पास एक अच्छा accountable system नहीं होगा, we can't do anything for the rehabilitation of children, at least, because I don't find that will in the system to work for children.
Right. You correctly pointed out actually.
One more
That's
thing.
the thing which we were talking
Yeah,
about.
yeah. And Sneha, you said no, both the agencies have to work together. When the
Right.
child is declared a CNCP, when it comes to CWC,
No,
actually, the
also
stigmatization
the state,
happens
ma'am,
there.
also the state, not only the CWCs and JJ, because water never flows upwards. The water has to flow downwards. Until and unless the state is willing, we can't do anything for the child.
Right. But ma'am, I think, Shalini ma'am, that's why different stakeholders have been made. But the problem with that is that what I have seen, or that for all of these instances which I was sharing, that Mulla committee, when formed in 1980-83, found 2,158 children incarcerated at different jails in India throughout. And that was then they commented that this is only about the survey of one day. So on that particular day, 31st of December, when they visited it was the data of the particular day. And they itself in the report mentioned this thing. If you allow me to read it out.
Ma'am, sorry to
Yeah.
cut you in between, but my question is, who are those people who send those children to the adult prison? Who are those, and what action have been taken against them?
See, there's a point of this that we cannot get away with the responsibility. Each one of us has a responsibility, right? In JJ Act, that's what we have been, throwing, because this section was not much on that. Otherwise, I would have elaborated on it. That's one layer of protections are there, right? One, when there is an apprehension, there was a memo. Then again, then where this the child is produced, you saw there is a summary inquiry. Then summary inquiry has to be only with SBR, right? Then there, if you talk about the age, that on age, there is a age, maybe there is all together entire jurisprudence which says that even after looking the child, if it looks like a child, you can grant him bail, or you cannot allow him to go. If he doesn't look but he states that he's a child, then also you cannot push him into criminal system, right? But not everybody is complying, right? Now compliance of that is again something is fixing accountability, right? That's what we are here for. No, because see, we cannot get away with this thing that it's not being implemented. Each one of us, each one of the stakeholder had the responsibility, be it SJPU, sorry, CWPO, or the probation officer with the specific report of SIR, whether the Juvenile Justice Board, whether DLSA lawyers, or the other lawyers, or the child itself also. The child also have voice to participate in the. I'm not making child any victim here, but also the participatory right of a child has to be also upheld, which is I'm seeing at JJBs they are not being heard mostly. And this agency they are always being deprived of that agency to the other stakeholders. So that's what we were flagging it here, that back when in 1980 this was the condition. Then 1983 there was a in jails of India, the Sheila Barse case, where basically when she filed this, there was 1400 children. And there was law also, right? There was law also, although it was a different law for different states. But even then there was 1400 and children were there, and she was forced to file a habeas corpus before the special Supreme Court, right? Now after that so many years, while we trace out even today, this is January 2016 to January 2021 data, which is more than 9681 children in the adult prisons. We are not even talking about the special homes, observations home, place of safety. These are all children who have been incarcerated in adult prison system. Somebody has to take responsibility. But as you know, when it goes to in High Court or Supreme Court also, like, who will be held accountable, right? Because each one of us had to had the responsibility of that. JJB also cannot get away with that, because the children was with before them also. If it looks like a children, they had to had pass an order, but which they didn't, right? So when you're talking about this accountability can only be brought into while action is being taken report, right? Now recently Delhi High Court and this Delhi government has have released certain guidelines with respect to these incarceration. So whenever a child is incarcerated or somebody goes and complains that a child has been treated as an adult, a complaint has to be filed against the person who had lost certain child into the system as an adult, and it has to be forwarded to through DCPU for the proper compliance. Now whether who will do this complaint, if nobody does that, then the system is not channelized. And why the state in a very complete, friendly family like a stakeholders. Why anybody will point out the shortcomings of other, unless you come, there is a rule, no, you have to come to the court with clean hands to accuse somebody else of something. So it has to be like, if JJBs are doing their proper duties, then only they can ask the DLSA that you have not been appearing on time and you have not been listening or going to observation home and listening to children what their requirements are. Have they asked when the social investigation report is placed between them? The kind of reports which I see in my files, SIRs are blank. They have some ticks, then there are columns which are completely blank. Now, who has the responsibility? Okay, probation officer breached certain thing. Who had to point out? JJB members. I, as a council, if I get the report or if I do the inspection, I have to point out. If I also keep mum, if all JJB keeps mum, then nobody is going to point it out, right? So I don't think so. This question of accountability could be so easily answered by raising allegations against others. But yes, every stakeholder has to take a responsibility now. This was with respect to the same, but there is some data of that, how the children have been and where are they have been incarcerated all these years. Yeah. This is the Juvenile Justice Act 2015 calls for the establishment. See, ma'am, this is what you were talking about. System needs accountability. The heading is the same, right? But the question is that who will take reform? It's this article is talking about reforms. There have been. That's how we have been tracing this. My whole point of making this evolution slide was the fact that we have already crossed that path of coming through that, then identifying the children, and but we are going back towards it. And the reason is just because we as a whole don't believe in juvenile justice system. That's my uh, personal opinion, that I don't think so. So unless we inculcate that sentiments in the society for the juvenile offenders or for the juvenile justice, there's no respect for juvenile justice in, among the stakeholders. When I go to JJB, I all every now and then I hear from the officials or like the staff that, ma'am, why are you wasting your time? These are the criminals. So that, and nobody put that much effort, that how why we are putting so much effort on an offender who is going again and back into the system and will probably be coming with the same behaviors and same propensity. Why to waste such time? Because nothing could be changed. So I think that why the system is failing is because of the fact that we don't believe. Now my personal recommendations or how we can pathway forward is, right, the civil society and legal luminaries. Now this legal luminaries is not the so-called very hyped people. It's like everybody, whether the concept of legal luminaries make it very glamorous that some high profile lawyers and all. No, it's talking about everybody, right, from JJB magistrate to the social workers to the SJPUs to the probation officers, everyone. Civil society, because whatever understanding I have of child rights, and that was the reason the social members were introduced in the JJB. So that, because we are very technical, right? If we see, if I see somebody has committed a murder, if a person commits murder and comes to me for defense, I quickly ask for the papers and I just look and make out my case. But when I started talking to a social worker or a person from a perspective of what society is going to deal with it and how JJ is going to deal with it, as balance has to be struck, like the recent cases, or let's not talk especially about Pune case, but any case in which we have seen a selective outrage and outburst of the society, which is like, suppose a sexual offense happened with certain brutality involved in it. It it attracts all the attention of the media, and the media trial together happens. But there are everyday violations. Now, if this slide, who will take the responsibility of this? Does media, does society ever made a hue cry about this? That 2,158 children, then 1,400 children, then these are all not even complied with JJ Act. They were altogether sent to, and there are no no period specified that for how much period they have been incarcerated in the criminal justice system. Who will take the accountability of these children now? And neither we have also never talked about this, to be very frank. The I pro bono report which came, and this we went to report, and then that's it. That's there is Has anybody talked about rehabilitation of these children? What are the accountability? Who will take it? So this civil society and legal luminaries collaboration is one of is that's how we may inculcate some sensitivity towards juvenile justice. Because how I'm seeing the debates nowadays in respect to the Pune case, it's about murder had been committed. I've seen the post, murder has been committed particular, then there are specific all the details of the cases are being highlighted, which is a very problematic thing, because these information couldn't be shared, could not have been shared without the involvement of somebody, from no breakpoint. A breakpoint has been detected in JJ system. That's how these informations were going out, because they were very peculiar, that this has happened, that has been found here, that has been found there. And if it has not been done, it has been asked to, such reports to be taken down from the media. But nobody has done that. Instead of that, a certain kind of uh, perspective or narrative is being built against the child. So I think that whatever child rights sensitivity has to be built is when both of the system works together. I have a lot of times when I am going very technically about, like, suppose section 12. If I would have taken section 12, I say that okay, it has to be released on bail, unless I was pointed out by the social norms and the situations that okay, these are three exceptions, and how would you justify those exceptions. Those were the basis for the society's need and the societal balance between both of the right of the child and that. So I think a practical and rational approach has to be adopted by all of us in saying, to in inculcating the rehabilitation process. Like, suppose I'm a child offender living in a slum. You give me that okay, you carry out hairdressing course 6 months. I am complying with that order. But what should I do after that? Is that a practical approach for me? Whether I could afford a salon afterwards, right? So all of that social situation or placing of a person has to be in par with the law. What are the things which we are adopting? What are the mechanisms which we are involving? Has to be with the same system, right? Second is recognizing natural rights and societal norm for robust system. Yeah, it's the same thing. That suppose this is more about, let's try to understand from the, it's a bit uh, controversial, but let me explain. Right to sex, right to sex, where is it defined? Is it defined anywhere? No, right? It comes into there. Now there are natural rights. Can you say, is there any research which say that a 10-year child cannot enjoy the fondling of his body parts, private body parts? You can't say, right? But then there are societal norms which says that yes, we recognize this fact, but there has to be certain age in d- until which the child, it's advisable to not to expose the child to certain situations or sexual orientation, because the consequences followed by certain offenses are not to be in the interest of the child, right? Suppose. So all of these consensual cases which comes around, how the courts are drawing the, like, there are 7 high courts up till now in which consensual cases, POXO cases, they have granted bail and all to the child, saying, because the POXO is very strict in the sense that it just simply talks about if there is sexual interaction between two people, it interaction, physical interaction, then POXO has to be applied, whether it's a consensual or not. But judges or the courts have carved out certain situation, and these has came by the realization that at that certain age of adolescence, teenaging, they have this a tendency to be curious about certain things, to be exploring their body. That right, natural, cannot be in conflict, cannot be seen in such a way that it should come in conflict with societal norms. And how to strike a balance with that has to be a very complicated, which cannot be done only with respect or with the help of legal definitions or legal terms. It has, we have to rely on source, civil society and other stakeholders, right? Channelizing each resource is the same thing, that the rehabilitation of any child cannot be done, or like, this again and repeat offenders, which we keep on terming them as repeat offenders. We very easily say that whenever I go to observation home, it's written repeat offenders, but nobody asked them that the first ICP which was done, were they all complied with? Are these, otherwise nobody has this, right of saying that this child is again a repeat offenders. If that person has not been given a chance to go through certain situations and facilities and resources to mold himself to a certain point, how could you ask? It's the same person who comes at a different point of time with you, right? So channelizing all the resources is very important. That saying, as ma'am said, that JJB has done, they have filed a very nice SIR, and then there was an individual care plan, then they have appointed a probation officer. Now, whether that probation officer is going and doing it with a holistic point of view or not, whether he's producing and constantly reporting it to the board through the or not, that is all has to be complied with. So channelizing every stakeholder is the one thing which might lead to a better rehabilitation. Oh god, I'm exceeding the time, I guess. Okay, believing in juvenile justice system is already we discussed that. I think, as you, Shalini ma'am, you were saying and we were discussing that, when I see selective outrage, is that society in itself, whatever narratives I have been hearing, is what I see. If somebody apart from juvenile justice system, I hear, they don't believe in juvenile. They just think that juvenile justice is an act in which a child can do anything and get away with. That's the very, very common man's understanding of JJ Act as of now, right? So that is something we have to work on. I think I'm done. These are certain case laws which Subramaniam, if anybody wants to, I can forward them. Shilpa Mittal versus NCT of Delhi, which talked about classification of offenses, that heinous offense, kaun se honge, serious offense, and then the petty offense. What are the classification basis? Kya hoga unka? CCLA is about the bail under section 12 with respect to a juvenile who was being tried as an adult. So if any appeal or any proceeding comes before High Court or Children's Court and the child is being tried as an adult, even then you can ask the bail under section 12. That is the peculiarity of this judgment. Right? Then Barun Chandra Thakur versus Master Bhuru is with respect to preliminary assessment guidelines, which says that during which word may has to be mandatory and not directory. The may should be read as mandatory and not as directory. Then Sheila Bar says the same in castration of children, and this judgment has to be particularly has to be read by everyone, because it traces how the law has evolved also, and how it should go forward. Lalu Kumar versus State of Bihar is a Patna High Court judgment of 130, running 137 pages, which talks about comprehensively about when a child, how come a child could not be could not be tried jointly with an adult co-accused. But it's not so simple. It also explains that what should be the consequence when both of the evidences are read together, how the witnesses should not be in with respect to all of these. Court on its own motion versus Department of Women and Child Development and others. That's 8889 2011 Delhi High Court. It's talk about incarceration in jail, right? Where the report has been filed and children have been found to be incarcerated in jails in Delhi, and there has been comprehensive deduction issued in this case, right? And also age memo. Age memo is something. Let me share this. In this case, age memo has been devised in the Delhi High Court, which Shalini Mami was saying that whenever a child is being apprehended, an age memo has to be filed, right? And in this, see, name of the arrestee, father arrest, date of birth, name of available documentary proof, agar hai to, agar nahi hai, who is informed, arrest to be done in case of arrestee does not know his age. Okay, so whatever, this age memo has to be filed so that no officer could say that we thought, or the child might not have told that he is a minor or anything, right? And if this is violated, then has to be a complaint against that person who violates this. So after that 8889 judgment, this is not being complied with again. This is not being complied with. Now the last one is Risipal Solanki versus State of UP. That is with respect to proof of age and claim of juvenility. It talks about that the section 94 talks about three specific proofs of age, and each one of is mutually exclusive of each other. Like suppose when I see that in PIR, when police investigation report, they file the 12th pass certificate also and the date of birth certificate also. Now if the both date of births are different, then there would be then would be a contention of which to be taken care of and not. So we'll go by 94. The Supreme Court has made it very clear that we'll go by this. So these are certain case laws which you could read for the jurisprudence of this. And before wrapping it up, there's one very interesting para in the Mullah Committee report which I would like to read out. Please allow me, bear me with some more time.
You can stop the screen sharing.
Yeah. No, I just wanted to show this one. Yeah, there is a growing tendency in our country to find solution to most of our, what is it? How could I do? Most of our social and economic problems through prisons, and even the solutions to the problem of the unfortunate children in distress are sought to be found through the imprisonment of children of tender ages in some states and UTs. We cannot imagine a more tragic and deplorable situation than this while making recommendations in the succeeding paragraphs about children in prisons. We have kept in view three aspects, namely removal of children currently lodged in prison, checking the present inflow of children to prisons, and development of child welfare services to curb the future inflow of children of prisons. The point was that we are still here. Vedayima, it's the same thing which we require even today. This was back 1980, right? And if you ask me or anybody, it's the same three recommendation which people will make even till now. So yeah, that's how. Any questions in chats?
Participants, you can raise your hands if you have any questions. We can take 2 questions maximum because we are running out of time. Rabia, yes, you can ask your question. You can unmute yourself and ask your question.
First of all, good evening, ma'am.
Good evening, Rabia.
Ma'am, I have 2 concerns. Firstly, the way the media portrays any juvenile cases. Like that is a major concern, and also the way religion is portrayed in India. Like we feel that when the child is born after initial 5 to 6 years, the child should know how to behave. Like there's nothing like social or family values are taken into consideration, it is believed that the child should know these things, even though the child is not taught. So, ma'am, about even media also, like why there is at one side we are saying there's a freedom of speech, but ma'am, it also has some restriction, right? Media can't show anything and everything. Ma'am, what's your opinion?
Yeah, well, you're absolutely right. Is specifically JJ specifically bars, that with respect to proceedings, nothing should be, uh, nothing should be shared unless that's the same in POXO and JJ also, and it has to be seen. These kind of things what we were talking about, that reports like these, that incarceration of children, these has to be circulated, but these are not being circulated. Rather, what you are saying, you talked about two things, no, religion and the media's role. So media's role, of course, but your speech of expression, see, speech of expression is with respect to a personal thing, no. If my speech of expression is harming your way, then my speech of expression can expressly be curtailed with, right there. It's also not, it has to come with certain sanctions. So I believe what you are saying, that yes, media has to be as and when restricted with, whenever it comes within the rights of the child. The religion thing which you are talking about is, see, I don't like to much comment on religion, but uh, religion, when it comes to religion, there is a lot of rigidity, right? Some even in within the religion, there are also a lot of other classifications and uh, what do you say, divisions. So in those cases, not on what is, uh, how do you put it, what is good for me in my religion might not be acceptable in other sects of my in other sects or something, right? So how do you define religion is a very problematic thing for me. I don't think so I will be a rightful person to comment on religion. I'm so sorry for this, but I didn't think so in comment.
Thank you, ma'am.
Any other have question?
Uh, so I think we don't have any questions from our participants as of now. So I would like to conclude the webinar. Uh, so I'd like to extend our deepest gratitude to Advocate Sneha Singh for her outstanding presentation on advocacy for child offenders and their rehabilitation. Ms. Sneha's comprehensive exploration of the Juvenile Justice Act, tracing its evolution from the pre-colonial era to the present JJ Act, provided us with valuable historical and legal context. Her discussion on the concept of parens patriae and the principles of child rights litigation illuminated the fundamental philosophies underpinning our juvenile justice system. She skillfully highlighted the transformation in legal approaches from protectionist to welfare and finally to the rights-based framework. The emphasis on the importance of the preamble in the JJ Act and the critical role of social investigation report offered us deep insights into the operational intricacies of the JJ Act. Ms. Neha's detailed explanation of the positive measures principle of Section 3 of the JJ Act and the rehabilitative provisions was particularly impactful, I would say. She provided a clear understanding of where rehabilitation begins and stressed the accountability of stakeholders within the juvenile justice system. Ending her talk with solid recommendations, Ms. Neha underscored the crucial roles of civil society and legal professionals, emphasizing the need to channel resources to all stakeholders and fostering belief in the juvenile justice system. Advocate Sneha Singh, your expertise and passion for child rights have significantly enriched our webinar series on child rights and well-being. Your insights not only informed but also inspired us to strive for a more just and effective juvenile justice system. So thank you for sharing your knowledge and your valuable contributions to this important discourse. So we also look forward to your possibility of having with us in the future. Thank you once again.
Thank you, everyone.
And with this webinar, we come to the end of the webinar series on child rights and well-being by Law Comrade. We would like to thank all the participants for their active engagement and insightful contribution and interactions. Our gratitude also extends to everyone who helped spread the word about our webinar series. So it has reached from even from Kashmir to the end of Tamil Nadu. So we are really happy about that. So we also appreciate the contributions of CWC members, professors, advocates, social workers, JGB members, students, parents, and teachers, and all the other individuals who are passionate about child rights and are dedicated to the well-being of children. So thank you so much, everyone, for making this series a good success. So I would like to see you guys again in a different series of webinars and discussions soon. So I'd like to ask everyone to subscribe to our Law Comrade YouTube channel for further updates and developments and initiatives of Law Comrade. Thank you so much, everyone.
Thank you, Subramaniam and Kritika. It's a wonderful initiative, and good luck to you for your future webinars. Thank you.
Thank you so much, ma'am. Thank you so much for your time and your contributions, ma'am.
Actually, I just want to thank Shalini Sharma and Vaidegi ma'am, especially for today's session. And your inputs from today's session in between the session was very thought-provoking. I was just thinking about that. So thank you so much.
Thank you.
Thank you very much. Thank you.
Thanks, everyone.